Welcome to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. We study change in order to make change, linking knowledge of the past to the quest for a better future. Every other week, we examine the most pressing issues of the day through a historical lens, helping us understand what happened then and what that means for us now.
Hello, I'm David Myers, host of this episode of Then and Now, which is sponsored by the UCLA Luskin Center for History and Policy. Today we're going to be speaking about the ever-present and deeply unsettling topic of the climate, the unprecedented new risks we face, and what we can do to prevent descent into a cataclysmic abyss. Many efforts today are focused on prevention, what we can do to reduce our environmental footprint and seek to halt further erosion of the status quo. Some are also focusing on another tool drawn from the arsenal of international law that would punish those who commit crimes against the environment. Echoing the more famous crimes against humanity and genocide, these advocates are attempting to define a new crime called ecocide that would hold accountable those who commit gross violations against the environment. One of these advocates is our guest today, Kate Mackintosh, an eminent human rights activist and international lawyer. For 8 years, Kate worked with Doctors Without Borders, providing legal and policy advice to operations in over 30 countries around the world. I got to know Kate well in the time she served as the inaugural executive director of the Promise Institute for Human Rights at the UCLA School of Law. In July 2023, Kate moved to the Netherlands, where she will serve as the executive director of the Promise Institute branch in Europe. Welcome to Then and Now, Kate.
Hi, David. Very happy to be here.
Great. So let's jump right in. The concept of ecocide echoes the concept of genocide, which was first enshrined in international law in 1948. So maybe we can go back to that era and you can remind us what was and what wasn't included in the Genocide Convention. And do you see ecocide as part of the idea of genocide or as its own entity?
Yeah, that's a super interesting question. So the definition of genocide is quite contested, basically because it has been settled more or less in international law that the Genocide Convention itself, so the international crime of genocide, requires physical destruction of members of a group, or at least attempts to physically destroy the group. Whereas a large body of thought is in favor of what's been called cultural genocide. In other words, destroying a group must include destruction of the characteristics, the culture, the social interactions, the practices that make that group a group, right? And I think logically a lot of us would support that. I myself think that there are practical, moral, logical, philosophical arguments for supporting that. And I think Raphael Lemkin himself was proposing this kind of concept of genocide. So the eradication of a group is destroyed if it no longer can practice its religion or can come together or can, interact with its environment, to move to the topic we're talking about today, in the way that is, significantly constitutive of it as a group. However, the international criminal tribunals that have adjudicated genocide have really come down on the side of saying cultural genocide itself does not violate the Genocide Convention. And that is mainly based on investigating the intention of the states that signed up to the Genocide Convention. So I think the original conception of genocide was much broader and would have included cultural genocide, what's become known as cultural genocide. But the way it's played out in international law, due to the perspectives of the states that signed up to the convention, is much more narrow. So that comes to your second point about whether genocide and ecocide are part of the same thing or broader. So particularly on the part of indigenous groups, representatives of groups that have different kind of epistemologies, which see humans and nature as very much part of the same system. And in fact, which wouldn't have a word for nature as something outside, the human world. The concept of genocide must include ecocide. To destroy the environmental elements of a society and a culture is to destroy that culture. And there's scholars have written about this, continuing to write about that to this day. But as I say, legally, that isn't really included. So it would be very hard to try and prosecute somebody for destroying the environment as genocide, unless you could show that they intended to physically destroy the members of that group.
So I'm curious then about what Ecocide says about the idea of rights. Genocide is focused on the attempt to protect the physical well-being of members of a group. In part, Ecocide seems to be intended to protect the environment. And I wonder if we can extrapolate from this proposed statute the idea that the physical world has rights, an expansion of our very concept of rights beyond human rights, beyond rights that can be ascribed to individuals or members of a group of the human race. Is that a correct implication of this idea of ecocide?
Well, I think the definition of ecocide that we've proposed, I was part of a panel which proposed a definition in summer 2021 to be included in the International Criminal Court statute. The definition that we proposed tries to encompass both protection of the environment as something which is important to humans and protection of the environment in its own right. In fact, I think ideally we would situate ourselves as part of the movement which is understanding that division doesn't make as much sense as, certain thinkers thought in the past. So typically there'd be a conversation about anthropocentric and ecocentric approaches to, protection or to international crimes and so on. And the critique of the current international crimes is that they are purely anthropocentric. So it would be possible to prosecute destruction of the environment, for example, as genocide or crimes against humanity, if it could be shown that it was part of the intent to destroy a human group under the Genocide Convention, or that it was part of a widespread and systematic attack on a civilian population, which would be the definition of crimes against humanity. But where there was destruction of the environment, where there was either no particular intent to destroy the group, even though it might be destroying a group, for example, we can think about, massive oil extraction or deforestation and so on, or where the link between the environmental destruction and human survival is not apparent to us immediately, then there's a lacuna in international law. And so that's where ecocide has stepped in. But as I say, in the definition that we've put in, we have included elements. So we've drafted it in such a way that a prosecutor or a judge assessing the crime could take into account the impact on humans, but could also take into account the impact on other beings, as well as on, the environment itself. So as I said, I think we're bridging, or at least we're attempting to bridge that ecocentric, anthropocentric divide. And, that's happening in a lot of other fields. So you refer to rights of nature movement, which is definitely becoming more prominent. And interestingly, quite a lot of the developments around rights of nature is happening within international human rights, which sounds as if it should be, somewhat opposed to the idea of rights of nature. So those boundaries are breaking down, actually, in a number of different fields, which I think is really interesting.
Interesting. So let's go back to the origins of the term itself. The term ecocide first appears on the international stage in the context of the Vietnam War. So can you explain the circumstances surrounding its arrival on the scene?
Yes, as far as we know, the term ecocide was first coined by Arthur Golston, a biologist who was horrified by the use of napalm and Agent Orange as a weapon in the Vietnam War. And he coined the term ecocide in connection with that. And that actually launched, or was part of, a whole movement to develop law which protected the environment in armed conflict, which we can talk about. But from that, there was the Vietnam War. I believe the term was first coined by Golston in 1970. Already in 1974, there was a conference to revise the Geneva Convention, so the major instruments that protect and regulate conduct in wartime, 74 to 77. And the result in 1977 were the additional protocols to the Geneva Convention, which then included specific protection of the environment. So there was a mood, a momentum to think about protecting the environment in armed conflict in the 1970s, which may well have been provoked by the Vietnam War. Another interesting thing, though, that happened in parallel to that was the veteran human rights lawyer Richard Falk, in 1973 published his suggestion for an ecocide convention. So still using the word, very much taking up the word that Galston had introduced. And he went a little broader. So he went beyond armed conflict and looked at or suggested that ecocide should include the kind of destruction that might result from industrial activities, for example. But he was really a lone voice in the 70s, a somewhat kind of visionary and prescient idea of the kinds of threats to the environment that we're most acutely facing today.
And that idea, that more expansive concept, not restricted to armed conflict, has prevailed in more recent formulations of the concept?
Yeah, absolutely. And it did carry on sort of in the background. There were two efforts underway at the International Law Commission, which is the body that's tasked by the United Nations with the codification and progressive development of international law. And two kind of long-standing projects within the International Law Commission were the draft articles on state responsibility. So, what are the responsibilities of states under international law? And a draft code of the crimes against the peace and security of mankind, which are very much provoked by the Nuremberg and Tokyo tribunals. And in both of those projects, the idea of the destruction of the environment being an international crime was raised and appeared in drafts that went to the General Assembly and that were discussed. In the state responsibility articles, that was dropped in the 1990s. And in the draft code of crimes against the peace and security of mankind, there was discussion about whether to retain a standalone crime of harming the environment or whether to include it under one of the other crimes. And in the end, it was retained under war crimes only. So again, it went just into the armed conflict suggestion. But certainly in the more recent, so in our definition, of course, we're not seeing armed conflict as the main driver of environmental destruction at all. There is actually already a provision in the Rome Statute based from the 1977 additional protocol to the Geneva Conventions that I referred to earlier. There already is a prohibition on causing severe, widespread and long-term damage to the environment in conflict with a kind of threshold provision, which actually makes it extremely difficult to ever charge. But it's there. So we were more occupied with thinking about destruction, outside the context of armed conflict.
Right. Let's pause for a second and go back to the Rome Statute, a very significant moment in the history of international law. The Rome Statute of 1998, which is a treaty that established the International Criminal Court. So what is the significance of that formulation that was included in the Rome Statute?
So the Rome Statute, it almost went in the other direction. So there is a world in which the Rome Statute did include a standalone crime of, severe destruction of the environment, but that is not what happened. And that may be linked to the fact that there was this parallel process investigating draft crimes against the peace and security of mankind, which sounds as if that should have been the Rome Statute, but actually it was a separate project, although that was within the auspices of the UN. And the Rome Statute, of course, was its own conference, so it's not a United Nations treaty. But because I would think, at least it must have been significant that this other project in the International Law Commission had dropped environmental harm outside armed conflict as an international crime. And I can only imagine that I don't know for sure, but I can only imagine that was very influential on the drafters of the Rome Statute. And there were, many other crimes that were considered at the time of drafting the Rome Statute. I mean, terrorism, other crimes that we think of as transnational, maybe rather than international, were discussed. And environmental crimes, may have been seen in that category. So standalone environmental crimes were not included in the Rome Statute. But as I said, the prohibition on war crimes, so crimes that are committed during armed conflict, does include this ban on causing widespread, long-term and severe damage to the natural environment if it's disproportionate to the military advantage that is anticipated. And that is a real snag.
Once again, the doctrine of proportionality surfaces.
Exactly. So there's the proportionality threshold is in there. And I mean, I think the prosecutor so far has just felt that it's too high for any successful prosecution. But, it's going to be very interesting to see if the current prosecutor investigates and brings charges under this particular article in the Ukraine situation, I think.
So the deployment of the war crimes mechanism was the preferred path here. And that, to your mind, has a limiting function because it restricts eco crimes to the battlefield.
Absolutely. I mean, it's just not the main problem that we're facing. It's not the whole logic behind the idea of ecocide, at least, from my perspective and the colleagues that I'm working with, is really this idea that an international crime is something which, wherever it occurs, affects all of us and is, so egregious that it's a matter of international concern, and it cannot be left to individual states to regulate it with their domestic criminal law. And the current situation that we're facing, the current emergency, the triple emergency of the climate, biodiversity, and pollution threat, that is, a threat that needs to be dealt with on the highest level. And it seems obvious that massive destruction of our environment, wherever it happens, is a crime against all of us. So that's very much what we were thinking about with this campaign and project to introduce a new crime of ecocide.
Can you tell us about that? How and when did you come to this particular question and involvement in trying to promote an international legal regime on ecocide?
Yes, I actually came to it. I used to work at the Yugoslavia War Crimes Tribunal, and it was in one of the positions I held there was essentially kind of running the court. And we were, I went to a meeting of international criminal courts in The Hague and East Africa. So we had Rwanda, and then there were chambers at that time being set up in Tanzania. Rwanda Tribunal was in Tanzania. There were chambers being set up in Uganda and Kenya. And so we went from The Hague, from the Yugoslavia Tribunal and the International Criminal Court. And the idea was to, swap experiences and be helpful. And a woman made a presentation to us, a fantastic activist, wildlife activist from Kenya, made a presentation to us about wildlife crime in Kenya. And she was really desperate and was saying, these animals are going to become extinct and we cannot deal with it with our national judicial system. Is there anything international criminal law can offer? And we all sort of sat there and said, well, I don't think so, because international criminal law is really about protecting humans. It's, to go back to our early conversation, it's very anthropocentric. But I was really keen to talk to her a little more about it. Her name was Paula Kahumbu. And I said, well, maybe if we could frame wildlife as part of the human environment. And as I said that, I thought, oh my goodness, international crimes against the environment, that is going to happen. And that should happen. And I want to be part of making that happen. This is really important. That's totally what we should be protecting. And I started trying to read, reading up and thinking about it. And I discovered actually that there was a British woman named Polly Higgins who was campaigning at that time around an international crime of ecocide. And it so happened that she came to speak where I was living. So I went to meet her. I spoke to her. I found out about the campaign, and I realized that there were quite a few efforts going on, actually. We're talking about perhaps 2012, 2013. There were a few initiatives in the UK and in France in particular around this idea of ecocide, but none of them were actually being worked on by people who were from the international criminal law world, which was pretty recent. The international criminal law is a very recent thing. The principles, the jurisprudence and so on has all really developed, certainly this century, but really in, the end of the first decade that we really started to get definitions of crimes and so on and so forth. So that's where I felt I could actually be useful, because I came from that world, and all this brilliant work had been done by environmental activists and general international lawyers. But I thought, well, this needs to be written in the language of current international criminal law to make it effective and to give it a chance of actually being successful. And I started actually at UCLA. We had a conference in 2020 on human rights in the climate crisis, the Promise Institute annual conference. And one panel looked at international criminal law as an option. And we had a day-long workshop the next day, a kind of expert group, where we started to flesh out what this might look like. And we carried on working with that group and we produced a couple of reports. And then Well, I suppose in that first year of the group, I was approached by the Stop Ecocide Foundation, which was actually the organisation which Polly Higgins had set up. She had tragically died at a very young age in a very short period of time. But the organisation continues, and I was approached by them, and they said that they were thinking of pulling together an international panel. And they'd been asked to do so by some Swedish parliamentarians, which gave it a somewhat official flavour. And I joined that panel, and it was fascinating. It was a brilliant group of people. I mean, very, very diverse in all ways. We had a former judge from the International Criminal Court from Samoa. We had a leading environmental activist from Bangladesh, a member of the International Law Commission from Sierra Leone, prosecutors, a leading international environmental lawyer from Ecuador. It was chaired by Philippe Sands.
The distinguished international lawyer and professor of law.
Exactly, distinguished international lawyer, and also who has written this wonderful book, East-West Street, which I'm sure you're familiar with, David, about the birth of the two most recent international crimes, genocide and crimes against humanity.
A wonderful book. I recommend it to all of our listeners.
Such a wonderful book. And so Philippe was really interested he's also an environmental lawyer. He's also written a treatise on environmental law. So this was, he was fascinated by this idea and this possibility to be in at the beginning and to help shape this new international crime. And he did a fantastic job, as did Dior Falsao, the Senegalese lawyer who co-chaired with him. And our mandate was to produce a definition which could be part of the Rome Statute of the International Criminal Court, so that would be proposed as an amendment to the statute. So it was very much draws on existing law, the existing principles, not only of the Rome Statute, but more broadly. We tried to incorporate environmental law principles along with international law principles, laws of war, and we issued the definition in June 2021. And I think it's had quite an impact. There are processes underway in a number of national jurisdictions to include a crime more or less exactly according to our definition in the national law. I think the most advanced is Belgium. Colombia also has, the Netherlands actually just recently introduced it. I'm just going later to meet the Member of Parliament who proposed it, so I'm keen to find out about that. At the International Criminal Court, which was our goal, of course, the amendment has not yet been proposed by a state, but a number of states have spoken in favour. And we're hopeful that this year might be the year that one of the states actually puts it on the table. That would have to happen by September. So there's a fairly short deadline because the amendments have to be proposed 3 months before the annual meeting, and the annual meeting takes place in December every year. But, it's being taken seriously, which I think was our main goal. We wanted to produce something that was something that could be seriously considered by government lawyers, by, academics, as something which, could work practically and which was based on existing legal standards, which is very important in international law.
So let's take a look at it. I'll read the statute as you and the group have defined it. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Here's an opportunity for you to gloss the statute that you've worked so assiduously on. What should we pay attention to here?
I think there are 3 or 4 points to note, which maybe don't jump out straight away. So we have 2 thresholds. We have, first of all, that the acts themselves have to be unlawful or wanton. And then we have a damage threshold, a substantial likelihood of severe and either widespread or long-term damage. Maybe I'll start with the second one. So first of all, I'll pull that into 2 parts. You'll see that there has to be acts committed with knowledge of a substantial likelihood. So it doesn't say acts which cause. Acts which are committed with knowledge that there's a substantial likelihood of causing.
So is that an intent provision?
That is more or less a recklessness provision. Yeah. So that's more or less recklessness. So we talked about this quite a lot. Of course, the point of this crime is to deter. And a recklessness standard is more effective in that way. What that means is you have to have known that there was a substantial likelihood, which is, fairly high. You have a substantial likelihood of this harm being caused. If we had said, you'd have to know that it will definitely be caused or that it would have to cause, there were a couple of drawbacks. First of all, we had scientific advice that this standard was realistic in terms of, the causation links between acts and environmental damage. I mean, some of them are very obvious. A massive oil spill, it's very obvious that that's going to cause environmental damage. Other acts, it's less clear. Obviously, it has to be, the accused has to have known that there was a substantial risk. But if you asked for the accused to know that it was definitely going to happen, that might mean that it was very, very difficult for a prosecutor to prove that level because of the, slightly, if we think about something like the extinction of a species, there's a very fragile ecosystem. You can't predict with absolute certainty what's going to happen with different interventions. But if you know that there is a substantial likelihood that that's going to be the effect, then that should be the point at which you think, okay, I'm not going to do this. Right? So we put that standard in. The severe and either widespread or long-term damage, that's taken from, you might recognize those terms, that was the language, or those were the three adjectives used in the additional protocol to the Geneva Conventions. But there actually the threshold is higher. It's severe, widespread and long-term. And we considered that again might be too high. In all cases, the damage has to be severe, obviously, because it's an international crime. But we considered that there might be something that was, more localized, but very long-term, or extremely widespread, but might potentially recover in, 10 years or whatever. I don't know what long-term, how the judge is going to interpret that, and it's impossible to pick an arbitrary number. So we thought it was would be better to use those two in the alternative. And we did actually have another international legal instrument which uses the three terms in the alternative: severe or widespread or long term. So we've picked kind of a middle path, thinking that for an international crime it was always have to be severe. And then maybe the last point to pull out is the unlawful or wanton acts. So one option would have been to just say unlawful acts. If you think about something like transferring members of the group, for example, of course that was perfectly legal in, the Canadian situation where Indigenous Canadian First Nation children were sent to orphanages or placed with, white settler Canadian families. So that was not unlawful at the time. And actually that's a good analogy for what we're trying to capture here. So if the act is already unlawful, then it's in. As long as it's committed with knowledge that there's a substantial likelihood, et cetera, et cetera. In environmental law, on an international level, not much is unlawful. International environmental law is all about principles and procedures, and it devolves to the national jurisdictions to set essentially a regulatory framework. Now, somewhere like the United States, the regulatory framework's pretty good, although obviously there are some issues around oil extraction, et cetera. But, there'll be other countries in which it's very lax. So there will be situations where an act that we consider should be captured because there's a substantial risk of it causing this high level of damage is not actually prohibited, because it won't be prohibited locally because of the way the laws are drafted. And there isn't an international law, fallback in environmental law that we could go to. So what do you do then if it's not unlawful? So we had to craft an alternate standard, and that's where we've come in with wanton. And wanton is a term which appears in international humanitarian law, in the laws of war in particular. In fact, unlawful or wanton together appear in the crime of destruction of property. Unlawful or wanton destruction of property is a war crime. So we were inspired by that, which we also thought was somewhat analogous, to use unlawful or wanton here. And so wanton would be an act that is just clearly excessive. It's a proportionality test, actually, David, to come back to the war crime. And that's also something that we modelled this on. We put our own proportionality test in here. But here, the destruction of the environment is not proportionate to the military advantage. It's proportionate to economic and social benefits.
If I can, Kate, I want to step back and think about the philosophical underpinnings of the move. What you're proposing through the statute is a criminalization of the crime of ecocide. There are critics of the international legal order, particularly the human rights regime, who say, and I'm thinking here of the political theorist Mahmoud Mamdani, that sort of human rights, as we've understood it since Nuremberg, has rested, the principle has rested on the criminalization of actions. And that's a mistake and excessively punitive and divides the world in kind of unnatural and inappropriate ways between perpetrators and victims, when in fact, in some sense, we're all responsible for the actions of the world in sort of the physical and political domains. And what we need to replace that regime of criminalization with is a regime of politicization and understanding we're all kind of political actors who share responsibility. I'm thinking of Abraham Joshua Heschel's famous aphorism, some are guilty, but all are responsible. So what do you say to that and to the impulse to criminalize as opposed to understanding eco-crimes as part of a political ecosystem, to borrow a phrase, that requires political solutions rather than criminal?
Well, political solutions are definitely required. I fully support that. And obviously, I think Mamdani's analysis is really interesting. I still see value in international criminal law. I was thinking about why I'm invested in this avenue and why I've spent so long working in international criminal law. I started being involved in human rights in terms of, thinking about them or studying or thinking, that would be a fun and interesting place to work in the late 1980s, early 1990s. And when I first, became aware of these concepts, there was always this question of, okay, that sounds amazing, but how do you enforce it? And then everyone said, well, yes, that is a little bit tricky. I mean, there's a committee and it can write recommendations. And there is this frustration with how do you ever make any of these beautiful utopian standards real and meaningful for people's lives. But then I lived through that period at the end of the Cold War when suddenly, I saw it happening. There suddenly was, these two international criminal courts were created for Rwanda and Yugoslavia. And I worked in Rwanda straight after the genocide, not for the International Criminal Court, on a human rights project. So, I was very deeply affected by that. And then these courts came, and then I got to work in the courts, and suddenly this law was becoming real. And, people were actually being held accountable. And I got to see victims come to the court and testify. And I actually, in a later incarnation at the Yugoslavia Tribunal, I actually spent a lot of time and invested in a survey that our victims and witnesses section did, interviewing witnesses over the life of the court about what it had meant to them to testify. But I didn't need that survey because I already had the anecdotal evidence of having been in court and have heard people testifying and see what it means to them. And, justice really matters. People really care about accountability. It's hugely important. And I remember thinking when I was working at these tribunals, like, what impact is this having on the world, right? I mean, what is this deterring future genocides? What's actually happening? And honestly, I'm not sure about the answer to those questions still. And I do think that, Mamdani has somewhat of a point. But what I was absolutely clear about and was able to hold on to as very motivating was like, this is really, really valuable for those people that are coming to court and for their communities. It's really important. And the judgments today, I've seen what's happened with revisionism in the former Yugoslavia. And they have those judgments that we have documented what happened. It's been examined in painstaking detail. Nobody can say those things didn't happen. And I think that's hugely valuable.
Right, because it's easy to be skeptical about the international legal arena, about the effects of the Genocide Convention, for example, because it hasn't had an enormously preventive function, one would assume. And yet your account reminds us that it can and has made a difference. And so I'm wondering if the Ecocide statute were to be accepted and it would be a crime before the International Criminal Court, what might make for a compelling case? Can you think of something that's going on in the world that, if you were the prosecutor, you might bring to the attention of the court?
I guess there are different sort of categories of cases that I can imagine. I certainly think that there have been some situations of oil extraction which might well rise to the definition of ecocide. I'm thinking about, for example, the Chevron Texaco situation in Ecuador. It seems like that probably would fit the definition. Depending on the level of responsibility and this recklessness question that we talked about, it could be that some massive oil spill or some kind of disaster might fall into it. But I mean, there would have to have been reckless behavior, right? I mean, an accident is an accident. And we're also not suggesting that negligence would rise to the level of the right mental state for an international crime. So you can imagine something like that. There's another of the papers that we're publishing looks at international wildlife crime. And in particular, where that is, could be said to lead to extinction, or at least the substantial risk of leading to the extinction of a whole species. That might rise to the level of ecocide. So, I think it could be a number of different things. I would probably, if I were the prosecutor, I would probably take something pretty straightforward. I actually think wildlife crime might be a good one to start with because it's already unlawful. It's already a crime. And I think that might be quite a straightforward prosecution to go with. The more complex question is how we would look at actions leading to climate change as a crime of ecocide, of course. But I think that's becoming less problematic almost by the month as, attribution science develops and it's becoming clearer and clearer. But obviously, even though it's a systemic crime in that we're all participating in it, to be potentially guilty of ecocide in that regard, someone would have to be, really at the top of some kind of power pyramid. So somebody who was in a position with their own acts, their own decisions to have really widespread impact.
And it's a person who would be subject to this stuff. It is not a state. The statute is directed at individuals responsible.
Exactly. Yes. So it could be a corporate actor, but it would be them in their personal capacity being criminally responsible. It wouldn't be a fine because we've seen how effective those are, right? I mean, there's loads of brilliant creative lawsuits against companies and they just factor it in.
So a final question for you, Kate. What do you think the odds are of the Ecocide statute being accepted? And can you reflect a bit on what it means to be an international lawyer at this time? And how much faith do you have in the system that it can work to make a better world?
So I think ecocide will become an international crime. I'm not sure what the route will be. I thought that there would be movement at the International Criminal Court a little faster than there has been, and I was not anticipating that there would be so much movement at national level. So that is very encouraging. Now, movement at national level supports movement at the international level. So, it's all good, but it's happened in different places to where I anticipated it would happen. I think it will become a crime, and I think it will become a crime for all the worst reasons. I think it will become a crime because of the emergency that we're facing, and I think at a certain point there will be consensus that, okay, we're going to pull together on this, and we're going to set a minimum standard, and below that, it's going to be something that is on the level of genocide or crimes against humanity because it's going to have such an acute impact on, essentially, on human life. And what's it like to be an international? Yeah, international law's been having a bit of a dip, I have to say. I like to think that the tide might be turning. We've seen some changes of leadership in some important countries around the world, including the one which our institution is located in. But also, I mentioned Brazil. There's all sorts of interesting developments in Latin America. I mean, as I said, Colombia's introduced this potential ecocide draft, but the Inter-American Court of Human Rights is really progressive. And there is really a very active and dynamic civil society on these issues, especially in Latin America, very impressive, leading the way. Small nations like Vanuatu has taken a leading role, both in pushing forward the idea of ecocide, but also in asking the International Court of Justice, so the court that deals with interstate disputes in The Hague, for an advisory opinion on state responsibilities in the face of climate change, which, if you haven't heard about yet, or if any of the listeners haven't heard about yet, this is a really, really huge development. So the General Assembly, in an initiative that was started by this tiny state of Vanuatu, has asked the International Court of Justice in The Hague, so not the criminal court, but the court that deals with interstate disputes, for an advisory opinion on state responsibilities in the face of climate change. So this is massive and so fascinating. That's on their docket at the moment. And states are able to, they've asked for submissions from states and international organisations. So we will be getting an authoritative legal opinion from the most respected and authoritative body in international law on state responsibilities with regard to climate change, probably over the next year, which is really interesting. So I think these kind of things give us hope as international lawyers, that we see it's actually important and doing something effective. I think an international crime of ecocide is massively important as a deterrent. It's important for us to say what's important to us. It's important for its expressive value. It's important as a deterrent to corporate actors in particular, where I think it could be really effective. So, yeah, even though international law may have had a few quiet years, I really believe that there are enough, how would I put it? We can't ignore international law. What we need to do as international lawyers is to make it relevant. And that's what I see happening. And it's all, I see happening all around me. I see really creative lawyers and activists getting engaged, especially around this issue of climate. And I think that is exciting.
Well, thank you, Kate Mackintosh, Executive Director of the UCLA Law Promise Institute in Europe, for a fascinating conversation. It's always great to be in conversation with you, Kate.
Absolutely, David. Really enjoyed it.
Thank you for listening to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. You can learn more about our work or share your thoughts with us at our website, luskincenter.history.ucla.edu. Our show is produced by David Myers and Rosalind Campbell, with original music by Daniel Reichman. Special thanks to the UCLA History Department for its support, and thanks to you for listening.